Paige Reese Whitaker. You guys, I told y'all she was gonna be fun. Y'all was gonna come in, blah blah blah, some more stuff, and then y'all was gonna hate her, and then turn around and then love her. Y'all gonna love her actor today because the way that she just made history and dropped a bombshell, bruh. Now, I don't change my mind on what I said about some previous, but I'll let y'all in on that. Doug Weinstein got up. We all like Doug over here. It made a case, basically, for charges to be dropped because that is the discretion of the judge to do. Matt Sharp made charges to be dropped, but we just gonna spoil it. He doesn't get the charges dropped, so we're not gonna bring it up because this would make this video about an hour and a half long, and I know y'all don't want that. So let's get on with Dougie Fresh and basically get to what he was trying to do to break it down, Charlie Brown.
That he does. And we are moving for a directed verdict on each of the counts against Mr. Kendrick, counts 1, 2, 50, and 57 through 63. And I'll go through each of those in order.
All right.
We're also moving for a directed verdict as to those overt acts that are before the 5-year date, before May 10th of 2017 in the indictment. Based on where we're looking at the jury instructions and the law, my understanding is that the jury is going to have to find at least one overt act that occurred after May 10th of 2017.
Right.
So I believe it would just be extra work for the jury and potential confusion if they were to sit there and go through each of the overt acts before May 10th, 2017. I understand that the state is allowed to put those into the indictment for a number of reasons. I understand that they like them in, or they want them in there in order to be able to quote unquote tell the whole story of the alleged racketeering activity. But since none of those overt acts can be used to support the any racketeering conviction, I don't believe that those overt acts prior to May 10th, 2017 should be before the jury for a decision. As to, just turning to the details of the different counts, as to count 1, Your Honor, the RICO count, in that situation, in that count, I don't believe the state has shown evidence upon which a rational trier of fact could find an overarching conspiracy seeking to achieve an overall common goal as required by the law. The state has shown a number, quite a few, I would agree, a number of individual acts they've presented. They have presented a number of crimes and alleged crimes committed by co-conspirators. But I do not believe that they have presented to this jury any form of an overarching conspiracy that would tie those acts together. The second part, I don't believe that the state has presented to the jury an enterprise that would be required, at least a criminal enterprise. I do appreciate that perhaps they don't have to show that the enterprise was criminal in nature. So I'm not going to spend a lot of time on that. I don't want to take up the court's time. I have some things in my written motion. Third, a pattern of racketeering activity is required for the RICO. This pattern, as you know, requires two predicate acts. They have to be within 4 years of each other. And the key that I want to focus on is that these acts have to be interrelated. And it's the interrelated portion of the statute that the state has not shown for the jury, and that a rational trier of fact could not find. Again, after watching this trial for a year, it's clear that the state has put on evidence of various crimes and alleged crimes. They've put on witnesses. They've had testimony from individuals that are alleged members of this conspiracy that have taken the stand and admitted to committing particular crimes. But they haven't shown at all that these crimes are interrelated. In fact, when the witnesses have taken the stand and they've been questioned, in response to questioning, they stated, I would say universally, I mean, it's been a year, so I don't know that I have everything in my head, but I believe they stated universally that they committed these crimes for themselves. If they sold drugs at a gas station, it was to get money for themselves. If they robbed somebody, it was to get money for themselves. There's been no demonstration that this was interrelated at all. There's been no demonstration, for example, of money flowing up and down the organization, and they could have attempted to show that. They could have subpoenaed financial records. They didn't do any of that. It's as if the state believes if they just show a tremendous number, and I guess we have close to 200 acts, if they just show a tremendous number of different acts, that's sufficient. And it simply is not sufficient. They can try to argue interrelatedness, and I am sure that they will, but they haven't demonstrated that for the jury such that a rational trier of fact could find the interrelatedness that's required for those predicate acts. Regarding count 2, the murder of Donovan Thomas, again, it's been a year. I could be leaving things out, but from when I have looked over the evidence that's been presented in this court, what I have seen them present, the state present, is Mr. Kendrick at a Texaco station inside of a Pontiac. And inside of the Texaco station, this Texaco station is a block from the location of the murder of Mr. Thomas. And they show Mr. Kendrick in and out of the Pontiac. They show him in a conversation with someone that may be in an Infiniti. But when Mr. Kendrick leaves the gas station, he's in a Pontiac. There's been no testimony at all, nothing, no video, no evidence that Mr. Kendrick somehow moves from the Pontiac into the Infiniti. And the Infiniti is what is alleged to have done the drive-by shooting of Donovan Thomas. There's been testimony from the state's own witnesses. I believe they presented an Infiniti identification expert that was able to identify the car that goes by as an Infiniti. It is not a Pontiac. Mr. Kendrick is not in anything other than a Pontiac. What else is the state presented? They have interviews that various individuals gave with law enforcement. I believe they have interviews that they presented in the form of video of Kenneth Copeland on June the 10th, 2015, speaking with law enforcement. They have interviewed, they have the plea agreement from Mr. Sledge. And by the way, that plea agreement from Mr. Sledge does not identify Mr. Kendrick specifically. And they also have Mr. Zachary's interview with Detective Thorpe. But in the case with each of those witnesses, when they've gotten on the stand, and the Sledge one is less important, I'm not going to focus on that. But Mr. Copeland, and Your Honor saw this, repeatedly told the jury that he lied to the police. He said anything he needed to say to avoid putting on that blue jumpsuit that Mr. Sharp so desperately wants to bring into the court and show to the jury. He would finesse the police. He would tell the police what they wanted to hear. He would sprinkle grains of truth into his stories to lend them credibility with the police officers. But when he took the stand, he completely renounced everything that he said previously. Mr. Sledge, as you well know, also renounced much of what was in his plea agreement, although, again, that plea agreement does not focus or even, I believe, mention Mr. Kendrick. And then again, Mr. Zachary renounces what he says on the stand. So I think that a rational trier of fact could not find that Mr. Kendrick had any involvement in the murder of Donovan Thomas.
Yeah, pretty much. So basically, what's supposed to happen is 2 or more acts are supposed to be implemented in the RICO, and that basically makes sure that you're done. Get you the F on out of here. And that's what he was trying to get to, and ultimately he made his point on the Young Thug house stuff and everything like that, because basically we couldn't figure out what the hell, just because you had a photo of you being there a day prior and then you probably walking up, because they never say really that they found him in the house the day that they came. They said the photo is from the day before, and then next thing you know, hey, he shows up, but he's not in the house, so he runs. Bro, listen, I run when I see the police all the time. I ain't did a crime in ever. I've never committed a crime in my life, but I still run when I see the police. So it is what it is on that one. So Paige came out and she said this.
Prior of fact. And the standard, as you all know, for a motion for directed verdict is not the beyond a reasonable doubt standard, that what the jury is going to be determining the facts on when the case is given to them. The standard at the stage of motion for directed verdict is that all of the evidence is to be viewed in the light that is most favorable to the prosecution. And doing it in that way, looking at it in that way, is there any evidence from which a rational trier of fact could find the essential elements of the crimes that are charged? So with regard to the motion for directed verdict on counts 1, 2, trying to do these in order. Now, let me just do it this way. I am denying the motion for directed verdict on all counts except I'm granting a motion for directed verdict as to count 59, count 60, and count 62. I do not believe that the elements of that even viewing in the light most favorable to the prosecution, there's evidence upon which a rational trier of fact could find the essential elements of possession of those particular items. And let me say that with regard to counts 2 and 49, again, is not a beyond a reasonable doubt standard.
Now, it would have been even bigger if he would have got acquitted of the murder of Donovan Thomas, but all it is hearsay. Like, it's no actual evidence and all of that crap and everything like that. The only problem, and I don't know if this would qualify as burden shifting, but they never produced anything to say where the hell Diamante Kendricks was anyways, but I don't believe that he had anything to do with it, because even Doug pointed out, like, hey, bruh, he wasn't even in the car. He sat there in the Bonneville the whole time. The whole freaking time. Now, here's the crazier part. 2 of the witnesses said they seen a Bonneville. But the state is so hard-pressed on the damn, I can't even remember what that car is, the Audi, that they might have messed it up. Either way that goes, bruh, I don't see none of them cats basically facing the murder charges now. The gun stuff, the drug stuff, and everything like that. I just don't feel good about it for Shannon Bumpus. Is that what we call him now? Shannon Jackson, Caleb Bumpus, Shannon Jackson, Stillwell Bumpus. I don't know. I'm staying out of it. That'll be the last stuff I say about that, because over there, bruh, I ain't gonna lie. I like Caleb Bumpus. She cool to me. She good over here. Miss Sylvia's good over here. Whomever in which all these people are beefing with, I ain't got no problems with nobody. I'm peaceful island over here. So the little jokes and stuff like that, trust me, Kayla, no, we good. But other than that, I'm not going to be making anything about it, because in all candor, it really don't matter. Is it messy? Yeah. Is it funny? Yeah. Is it entertainment? Yeah. But do we really care? No. There are people's lives on the line here. So that's how we're going to operate on this channel. But yeah, so that was the bombshell that she dropped. State, y'all effed up. The fact that y'all could go ahead a year and present some stuff, and then the damn judge says, pew, 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 get on out of here. I know what's going to end up happening. Well, I have an opinion. I have an idea. I don't want to say I know, because I can be wrong. And hopefully I'm wrong on one side and right on the other side. If these cats are convicted, it's because the RICO statute in Georgia is so insane that you gotta hear this stuff. I'm gonna read you something that is extremely alarming that me and Doug had talked about, but neither one of us could absolutely make this statement so eloquently and so succinct and so damn powerful and shocking. Check this out. This is from ALMlaw.com, Daily Report, right? Robert Wilson, Manu Birmani, Aurora, and Jennifer Hyman of Aurora Law in Atlanta. Check this out. This is commentary, but this is exactly the crap that we're talking about. The metamorphosis of the Georgia RICO statute. Check this out. Although RICO was created in response to organized crime, the Georgia RICO statute is far more expansive. This means that prosecutors can bring RICO charges against any corrupt criminal enterprise. Now, here's where it gets interesting. Over the past few years in Georgia, the prosecutor's crime du jour has become the RICO statute, Racketeer Influence and Corrupt Organizations Act. RICO allows the state to charge and convict people under novel theories for acts that may not fit into the standard definition of a crime. Think about that. That is dangerous. They said, we just got a theory on it, and we can get you. These cases often spark debate over whether the activity was in fact a crime or simply immoral. Congress passed federal RICO in 1970, and Georgia followed suit, passing its own RICO statute in 1980. The impetus of the RICO legislation was to tackle organized crime. Prior to RICO, the problem prosecutors faced in fighting organized crime was that those in command of the organization could shield themselves from liability since they never did the dirty work. Although RICO was created in response to organized crime, the Georgia RICO statute is far more expansive. This means that prosecutors can bring RICO charges against any corrupt criminal enterprise. Historically, this definition of enterprise included organized crime or street gangs, However, enterprise has now been stretched to incorporate businesses, school teachers, churches, political protesters, and even a sole proprietorship. In fact, the definition of enterprise goes even further to ensnare groups of people who have never met one another but can be charged as if they had committed the crime together. Remember when I told y'all Lil Rod never even met or knew Young Thug? There you go. The state, in its discretion, can group almost any collection of people into a criminal enterprise. People need not have ever met or even have known of one another's existence. In fact, a person's completely legal and mundane actions can form the basis for a RICO charge as long as another member commits 2 or more predicate crimes. In other words, a person does not need to have done anything wrong or illegal to be a part of RICO conspiracy. Think about what the hell I just said. In other words, a person does not need to have done anything wrong or illegal to be part of RICO conspiracy. All that is necessary is that their actions furthered the same overarching goals as those who actually committed the crime. Trying to determine what kind of conduct constitutes the crime of RICO seems to be only limited by the state's theater of mind. What? Some crimes need no explanation, e.g. murder, the R word, theft. RICO, on the other hand, is far less intrusive. RICO requires the commission of 2 predicate crimes in some organized way, aka pattern, or the pattern, for a common purpose. If that wasn't convoluted enough, the Georgia RICO Act is referenced across 12 separate criminal code sections and contain lengthy definitions for many of its terms. What does means mean? While RICO has been on the books for decades, the state's love affair with the statute is a relatively recent phenomenon. Not only does RICO not have any clearly defined legal guardrails, it actually allows the state to admit what would be deemed irrelevant evidence in most criminal cases. These issues make RICO ripe for creative and novel interpretation, aka rap lyrics, social media posts, clothing. This isn't in the freaking words that I'm reading, but I'm just reminding you guys of all of the things. Slang words, slang terminology, that arching ring a bell. These issues make RICO ripe for creative and novel interpretation. Historically, vagueness in the statute benefits an accused. However, with the RICO, the state uses the vagueness as a sword to charge people because RICO doesn't say we can't do it. The legislators that drafted RICO intended for it to apply only to actively motivated by pecuniary gain or economic or physical threat or injury. However, the state routinely argues that this language does not limit its discretion. They boldly argue that the only limit of who can be ensnared in RICO's clutches is based on the state's discretion. The state claims the line is fluid. Much like, I can't say that, but corn, they will know it when they see it. Until we get a high court ruling about RICO's reach, there is nothing stopping eager prosecutors from charging as they and only they see fit. Until we have the clarity about who can get swept into RICO, heed your mother's advice. Be careful who your friends and associates are. Yeah, that's insane. That's insane. Do y'all realize you could be hit with a RICO and didn't even know it? This basically like this. Let's say, fellas, you got yourself a very beautiful woman. Ladies, you got yourself a very beautiful man. And literally, they ain't got no job or no anything. But what they ask you one day is, hey, you think you can give me like $250? And you don't say anything. You just, boom, give it to them. And then they come back and they say, here you go, here's your $250 back. All right. Then a month goes by and they do it again. But they say this time, hey, you know what? Before I gave you $250, I'm going to give you $500. And you're just like, dang, thank you. You just became a part of a RICO. That person, your beautiful person, was out there selling drugs. You had no idea. Zero idea. Do you know that that's what they can do? It's absolutely insane. Bruh, there is nothing, and I mean nothing, stopping any freaking prosecutor in Georgia from doing this. I counted 7 times up until, because there was this group of people. The last time the Georgia RICO was used was against this Stop Cop City. I think it was like 82 people indicted, or 62 or 28. But I want to say it's 82 people that got indicted for it under RICO. Yeah. Now, listen, we ain't anti-cops. We ain't pro-cops and anything like that. I believe wholeheartedly that nobody likes the police. Just going to be honest with you. I thought defund the police was an amazing thing, and then you just found out how much people despise the police, because defund the police literally meant cut up the money that is divvied to the police officers, because a cop should not be responsible for half the stuff that they get called for, like mental stuff. And then some of you morons, because it's only like this many, some of you morons that are trolls will get on here and say, well, what about when the people who are mentally unstable, what are they like 6'3" and 300 pounds? You don't think people in the institutions are already handling those individuals? You think that this is novelty, that this is a first time? No. You do not need the police called when y'all can't figure it out with who needs to be with who during a civil dispute over children. Yeah, the police don't need to be called for everything. There needs to be a division. When you morons get gypped out of your money because you needed an extra patty and extra cheese on your goddamn triple cheese sandwich, but you only got a double cheese sandwich. Okay, that was me. My bad. Cops, I'm sorry for calling you on that one. My bad. My fault. My fault, Sheriff. But either way it goes, the cops don't need to be used for everything. You need different divisions of police, just the same way that we got the FBI, the ATF, the DEA, and all of this crap. Well, yeah. Then I diverge. I continue on. So, the reason why I dropped that is because these next 2 clips, I'll probably only play one, is highly important, because what they are trying to argue, and even Paige Reese Whitaker had to come out and say, hey, y'all, I never even tried a RICO. Yeah, no shit, Sherlock. Only 7 other judges have in Georgia history since they adopted it in the 80s.
Get input from y'all. I don't know.
Well, that might work. I mean, my concern when I read this was I thought we were back to the point where we were looking at a list that just tracked every overt act in the indictment. And I can see a lot of reasons why that could cause problems.
So it could either be, you must unanimously determine which interrelated types or acts, that one's still up for debate, of racketeering activity the defendant agreed would be committed, and then have them listed, or that interrelated types of racketeering activity would the defendant.
I think all they have to decide is that they contemplated committing interrelated acts of racketeering activity.
Well, they agreed to, not they contemplated it. You could contemplate it and reject it.
Fair enough. Okay. But that's really the question before the jury is, did the agreement contemplate what would ultimately have become a substantive violation? I'm very concerned about using the word acts, because you can see how they could get all hung up on that. And that's not really what the conspiracy law requires the jury to determine is the specific acts. That's what we talked about yesterday. The federal cases I cited to you, they all say they don't have to determine which specific acts were contemplated, only the types.
But even those federal cases say that the jury has to be unanimous on the types of acts that were committed. You'd agree with that, correct?
Whatever the jury's deciding, they have to be unanimous. I agree with that.
And
All right,
unanimous on the types of acts.
Don't talk to each other. Got to talk
sorry.
through me. That's just how it works in court. You know that. I know you didn't mean anything by it, but
I
it
always
sometimes
enjoy
devolves. I don't think it would with this particular crowd we have right now. But
Anyway, Your Honor,
yes.
I believe that the federal cases that Mr. Floyd cites would require the jury to be unanimous in the types of racketeering activity, and I think it would be necessary for them to indicate which are the types on their verdict form.
I don't think it's required.
Well,
trying to
shall we
figure
say
out-
helpful? I'm trying to also contemplate if they're as if there is, as Mr. Steele might say, God forbid, a guilty verdict in this case, and an appellate court is reviewing, I think without some tiny level of, I even hesitate to call this detail because it's so high level, but some guidance on the basis for the jury's verdict, that it would be difficult to review. And also, we would want to ensure that they are unanimous on the type. So if they indicate the type, that would ensure that.
But, you know, here's my issue with type. I mean, so let's say they don't decide, or the jury doesn't think, oh, they decided they would murder every op. Let's say they think they decided, you know, we're just going to hassle Lucci in any way possible. So we're going to steal things from Lucci. We're going to stab Lucci's mama. We're going to do X, Y, and Z. Those are different types of racketeering activity with the same victim. So it doesn't have to be the same type. And that's correct. So that's the wrong word to say.
And it's the one that crept into the case law, but I think
it's wrong. And I'm sorry, I'm kind of like thinking through this as we do this, because I've never done a RICO case before as a judge.
And I've never done one that didn't have a new issue pop up that I never thought
Right.
before.
But
as Mr. Floyd says, that is the language, as unfortunate as it may be.
well, I'm not going to. I don't care if language is in a case. If it's wrong as law, I'm not going to use it.
So, Your Honor, to follow up on the point you just made, in this case,
Yeah.
what we are really talking about with this enterprise, with this criminal street gang, is an open-ended conspiracy, because they're going to do what they decide to do. And once you're in, you're basically agreeing that you're going to do what that enterprise is going to do. As long as these are things that such an organization might accomplish when you sign up for it. And this is what, when you look at the older U.S. Supreme Court cases, one that sort of states the bedrock principles, like Pinkerton, for example, basically says, you know, you sign up in a criminal endeavor, you're on the hook for whatever follows from that. The solution to that is not to sign up for it, is not to become joined into it. And in a gang like this, an organization like this, sort of one of the fundamental tenets is acts of violence and threats of violence against those you perceive as your opposition or competition. You know, that's the path. You know, the real question is, are you agreeing to join in an organization that does those things?
But
And that you or somebody in that organization would do them.
Well, right, yes, but that's my point.
Well, I mean, that's the rub.
That's within the contemplation. I mean, when you're joining up, those things have already happened. You already know this is what this organization does. It's not like you joined the Boy Scouts and you found out that they're engaged in acts of terrorism. It's like joining a terrorist organization and finding out they're engaged in acts of terrorism. This language that we have here is getting at the point, which is, do they contemplate interrelated acts of racketeering activity will occur?
And we do.
And I guess we've already said it up above. If we're not going to say what was it, then we've said the state must prove the defendant knowingly and willfully agreed to join a conspiracy, understanding that one of them would commit at least 2 interrelated acts of racketeering activity within 4 years of each other to do one of these 2 purposes.
And in Georgia law, with the statutory definition, we pick up the same types in there. I mean, it's kind of baked into the definition that you've already got in the instructions.
But, you know, we're in a situation where, and I understand it, where the state does not want the jury to go through and say, we find this act, we find this act, we find this act. And that's the same thing that happened in these federal cases where there was an argument you shouldn't have to find specific acts. And I think that's why the federal courts have gone to, okay, fine, you don't want us to look at these, to have the jury identify specific acts, but they do need to identify, I guess they went one level up to types of acts that occurred.
Well,
But was that a conspiracy case? I mean, as long as I'm saying you have to be, I'm sorry, that you have to be unanimous that they proved all these things.
Go ahead,
I don't
Mr.
mean to
Floyd.
interrupt you, man. To be clear, the cases that I was talking about yesterday, those aren't verdict form cases. That's where the request was that the jury be asked to fill out a form that went through every single one of them. And they said no, and the jury was instructed on types, not that the jury filled out a form on types. We don't want to get, it's not a, I don't want us to back into giving them an essay question. That's not what we ask juries to do. Juries say yes, no. And if we kind of open it up for them to express themselves, I think we're asking for trouble. There's a good reason why.
And again, I'm not requesting a essay from the jury. I just think that having them identify what is the type of activity that they have found, or, I mean, it's not my preferred outcome, but some form of check the box, as the state may have indicated, perhaps just some guidance more than yes or no. And I appreciate that that's what the state would prefer.
Do y'all know that technically, I forget what dude's name is, but technically he's right? Just by thinking about a RICO with somebody, that's the conspiracy? Bruh, it's so doggone crazy that even when she admitted it and all that stuff, she basically was like, nah, hold on, homie. And this is where I think all of you guys are going to like Paige Reese Whitaker, because technically she was not supposed to agree with that. She was actually supposed to say, yeah, according to RICO, yeah, you can, just by thinking about it with somebody else and you guys conversing about it, that, yeah, that's going to screw over everybody. And I'm listening like, damn. So this is what's going on? Bruh, this is very, very poisonous. Y'all worried about so many individuals. And please, all you people, I'm not political at all. I told y'all who I would have voted for, or well, who I thought would have won, but I stay in a red state, so it really didn't matter who I voted for, because none of y'all, well, I won't say none of y'all, that's a big lie. A small minority of y'all don't understand how the Electoral College goes. So me standing in a red state that does not vote for anybody but Republican didn't really matter. So my local politics matter, and don't worry about it, because I don't bring up religion, race, or politics on my channel like that. I do sometimes, but some things be pissing me off. But either way, bro, that RICO statue is insane. And by her standing up, y'all got to give it up to Paige Reese Whitaker, because, bruh, Paige, she basically put on a Superman cape and said, hey, I'm standing in the way of what's wrong and stopping it right here. She said basically, bruh, hey, if it's wrong, it's wrong. And she's technically wrong according to RICO. So my theory that I told y'all in the beginning is, if the state does not get what they want as far as verdicts go, they're going to appeal the decision. I damn near guarantee it, because they have the right to, according to Georgia RICO. And I know there's going to be some people on it, well, that means you just want the state to win. No. Facts over feelings. That's what the Georgia freaking RICO is, where things cannot even make it in a regular doggone trial. And we all, including myself, was throwing up middle fingers to Judge Earl Glanville, the Honorable Chief Justice Judge Earl Glanville. He was actually right the whole doggone time. By permitting a bunch of BS, he has created case law. Paige Reese Whitaker, in the closing statements and stuff that she did today, has now created case law. And it's wild, because we are now getting educated on stuff we never even knew could possibly affect us. And I would even say, damn it, y'all better be aware out there in Georgia, bruh. If y'all committing crimes and all that crap, bruh, and you got homies, and y'all think y'all some hustlers and y'all competing against each other, y'all ain't even organized or nothing like that, y'all committing RICO and don't even know it. So if you're doing anything illegal, you can be charged with a RICO, and a mandatory 5, a maximum of 20. Understand that. Remember when we did the freaking reading, when Judge Whitaker was doing her reading of the sentencing and all that, and you just see me calling out 5 to 20, 3 to 7, whatever to whatever, and all of this stuff, and we were sitting up there like, damn. But ultimately, I think Diamante Kendrick gets time served, gets some probation. But I hope not, bro. Like, I truly, truly hope not. And the worst part about it is, I thought we were going to get a verdict by Wednesday. I kept pushing it back because with new information, you're supposed to change your mind. But the closing parts of this is going to be so insane that y'all know me. I gotta speak in on it a little bit about closing and as far as who had the better one, and we're gonna critique it state wise, and then we'll do Saturday state, and then Sunday we'll do the freaking defense, because what's gonna happen is they're gonna make their case for closing, and then the freaking defense is gonna make their state for closing, and then they're going to reclose, and then the other party's going to reclose, and then we're basically going to be done. And if they are back, and I believe they will be, if they are back within 2 days, that is tremendous. But if they are back in 3 days, I think that Mr. Jackson will be going to prison. I think that Mr. Kendrick might get a little prison time. I don't think they're going to get life, and that is the thing that I believe both families will be excited for, is that, hey, at least he has a release date, and that's the thing that was most important about everybody who took their plea deals. The effed up part about it is no matter how valiant and how gallantly these freaking lawyers fight and put up their best efforts, the law is really not on their side. But share to keep your people aware. Subscribe, turn on that bell to stay notified. And if you want to see this do its thing, just go ahead and leave it a like. If not, y'all want to be selfish? Hey, y'all know the visionaries. It is what it is. I do this for y'all, man. But I'll catch y'all tomorrow. Unfortunately, I'm not going to make it to court tomorrow. But Friday, I will be there.